Hello and welcome to episode 44 of the Speed Mooting Partners in Crime podcast. With this being episode 44, I'm sure you'll have no difficulties in guessing who this podcast was named after. It was a fun episode and it was mainly dedicated to answering your questions. So we answered questions in relation to mooting, and we also answered some career-specific questions as well. So hopefully lots of great information for you aspiring lawyers out there. And we concluded with a pretty important topic of discussion. As I'm sure you're all aware, the Royal Rumble is coming up this weekend. So Hayley and I discussed our predictions as to who we think is going to win the Royal Rumble and obtain their golden ticket to have a title shot at WrestleMania. It was a fun episode. We enjoyed recording it and we hope you enjoy listening. Welcome to the podcast. We are live.
Hi everyone.
Yeah, hello, welcome to the podcast.
Welcome.
This is the Speed Mooting Partners in Crime podcast, episode 44.
44. And if you watched last week's, we asked you to guess who this podcast was going to be named after. Yeah. Let's see if people got it right.
Let's see if they got it right. Now, normally I give a bit of an introduction, give some clues. I think, Hayley, you know this one without me even needing to give any clues.
Mm-hmm.
So, 3, 2, 1. Who is this one?
Lewis Hamilton.
Lewis Hamilton. So, yeah, I mean, normally I have to give a bit of an introduction. I think probably, well, maybe not every person, but pretty much any person that hasn't been living under a rock for the last 17 years knows Lewis Hamilton.
Yeah. So. I think even pre-John, I knew, before I even really knew what Formula One was, something about car racing, I knew who Lewis Hamilton was.
Yeah, I think
everyone knows. And for some reason, 44, I just remember his number as well.
Yeah, I don't know what it is. It's just so synonymous with him. I mean, you know, fair play to Lewis Hamilton. He loves that number. So when it was 2014, I've probably said this on a number of podcasts now, but it was 2014 when the new numbering system came in, which is drivers pick their number and that number sticks with them for life.
Yep.
Previously, it was the world champion got number 1, their teammate got number 2, and then all the other numbers were dictated by where their constructor fell in the world championship. So if you drove for the constructor that finished second, your drivers would be 3 and 4. Constructor that finished third, 5, 6, etc. There was no number 13 for some reason, so it jumped.
Maybe it's because it's unlucky.
I think so. But anyway, 2014, the numbers came in, with the exception of the world champion. So the world champion is entitled to run number 1 on their car. So the first season it was in, Seb Vettel, he was world champion, he ran number 1. Then 2015, which was the year after Hamilton won his first world title with Mercedes, he said, no, I'm sticking with 44. And he's decided to run it all the way throughout his career.
Wow. I like that.
Yeah, do you know what? Fair play to him. I don't think there's many people that would turn down the opportunity to run number 1 on their car.
Mm-mm.
So, yeah, fair play to him. Interestingly enough, do you know where that came from?
Nope.
So, like a lot of the drivers, they've chosen their karting number. So, Alonso was 14 in karting and, you know, things like that. But Hamilton was 44 when he was karting. And the reason he picked number 44 was his dad had 44 on his license plate.
Oh, that's cool.
That's cool, isn't it?
That's very cool.
Yeah. So, I mean, there's, you know...
You race under number 21, do you?
I do. I've changed numbers over the years. I did have 17 a few years ago, but now I run under number 21.
Our house number.
Yeah, the house number.
Surprised you didn't pick 8, actually, because your birthday's like the 8th of the 8th.
Yeah, I could do, actually.
Oh well, you got 21 now.
Well, to be fair, the season's not started yet, so I could change my number. Could change my number.
Interesting.
But yeah, I like to say a little bit about each driver. What can you say? Most weeks I say, you know, such and such a driver, they're quite good. Could you say that about Lewis Hamilton, do you think?
I think you've got to admit that he's one of the best.
I mean, not one of, statistically the best driver of all time. The highest number of world championships, most race wins, most poles, most... Pretty much any stat you think of, he's done it.
Yeah.
So I think it's pretty hard to argue against Lewis Hamilton being a good driver. Well, not only a good driver, you know, a very, very good driver.
Yeah.
And, you know, different people argue different things about this, but very, very easy argument to make for him being the best of all time. Yeah.
And I felt quite sorry for him last season because he was having like a hard time. And I remember seeing one interview and he was like, they were like, well, Lewis, what happened? And he was like, I just haven't got it. I just haven't got the pace.
Yeah.
And it's like, no, Lewis.
No, and he, let's be honest, he won 2 races last year in a Mercedes-Benz that shouldn't really be winning races. Likewise, so did George Russell as well. And we'll speak about George at some point, but he's going to have a great career. But I felt a bit sorry for him, and I think,
really hoping with the Ferrari.
Yeah, I hope this gives him a new lease of life, and I think it was the perfect time for him to jump ship because the powers above were basically saying
it was time for new blood.
Time for new blood. Same thing happened with Michael Schumacher when he was at Ferrari. I think he did 11 seasons, and they kind of said, well, we want Kimi Räikkönen and all the rest of it. So the same thing happened with Schumacher, and he decided to retire.
Yeah.
Which I think, if he didn't, I think he'd have won 2 more titles with Ferrari. But, I think it's that time. I think he's been with Mercedes 12, 13 years, whatever. Well, the brand a lot longer, but the Mercedes-Benz works team for that long. He just needs a new lease of life, and hopefully that's what Ferrari can give him. So,
boom.
Let's see what this season brings. It's going to be an exciting season nonetheless because the regulations are the same as last year. And, we have 4 cars that won, 4 teams that had 1-2s actually, which has never been done before. So this season's going to be fun and it's open. Anyway, it's not a Formula 1 podcast.
No, it is not.
Much as I would like it to be, it's not. So let's move on.
So to give you all a little update on where we are, it's first thing Friday morning.
Yeah.
Friday the 31st. Oh, it's the last day of January.
Last day of January, yeah.
Thank God. January was just like the longest month on the planet.
I don't have this problem, but everyone's it's so long. There's 100 days.
It is so long. I think because I always have loads to look forward to. It's my birthday in February. It's our anniversary in February. It's Valentine. So it's a really nice month, February. But January is just like on and 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 on. It just goes on forever. Anyway, so it's Friday morning. We're recording this podcast for you now. Immediately afterwards, John's got to run off to court.
I have.
Because we've had such a busy week.
It's been crazy, hasn't it?
Yeah, I think you had like 2 trials in one day.
Yeah, literally yesterday, two trials in a day, and I found out literally at lunchtime. I was briefed on the second one. The judge said to me in the morning, he said, I've got another trial in the afternoon, is that you? No. Came back after lunch, say yes, I've been briefed on the afternoon matter.
2 trials in one day. You've been working pretty much every other day as well.
Yeah.
You've got another big trial coming up, so you're trying to prepare for that. You had how long was your skeleton that you had to read last night? Like 80 pages?
24 pages, 80 paragraphs, 24 pages, crazy.
Yeah. So it's a very, very busy time, and then obviously we've got all the speed moving stuff going on as well.
There was one day where I was in Sheffield in the morning, and then I had to come back to Manchester for the afternoon for a hearing, and that hearing went on for a long time, so it's been an intense
very busy week. Yeah, so we intended to record this last night, didn't we? And then it got to like 10:30 and we were like, no, we'll get up early and we'll do it before John goes off to court. So here we are, and because of the time constraints, John can't be late to court.
No.
We're going to stick to an Ask Speed Squad special for you guys. We've got a couple of questions, so we're just going to answer those, and normal service will hopefully resume next week.
Yeah, fingers crossed. Fingers crossed.
Cool.
Right. Let's dive into the questions then, Hayley.
Let's dive in. So this week, that's another thing we had this week. Advocacy Club on Tuesday.
Oh, of course we did, yeah.
So it was a speed mooting special, and it was a really, really great meeting. So everyone got to have a go at mooting, have a go at being a judge, come back, listen to John give some feedback on mooting, and then we had a general discussion about mooting, and we got so many questions that we had to take some offline and answer them on today's podcast.
Yeah. Yeah, we even ran over this week, didn't we?
We did run over. Everyone was very, very engaged, which we love to see. Okay, so we've got a few questions to get through, and you will notice there is a mooting theme to most of these questions.
Okay.
Because they came on the back of our Speed Mooting Advocacy Club session, as I just said. Important to note, though, if you're listening going, oh, I didn't know about mooting, Mooting is obviously practicing advocacy for the real thing.
Yeah.
So all of these questions and all of these answers are transferable to real life courtroom advocacy. And that is the reason why we say mooting is so important for aspiring advocates.
Indeed it is.
Let's get right into it, John.
Let's jump in.
So the first question that we had, when making submissions and laying out your structure, do you say to the judge, I have 3 points to make? The first point is X, second point is Y, third point is Z. Or do you just say, I have 3 points to make, my first is X, and go right into it?
Okay, so this is a question about structure. And in terms of your structure, it's pretty much the generic structure that you have for any form of presentation and public speaking, which is tell someone what you're going to tell them, and then tell them what you just told them. So intro, main body, conclusion.
You've got to copyright that phrase or
really
something.
It's
I love that one.
But that's public speaking in a nutshell, isn't it?
Yeah.
So what this individual is asking about here is the introduction, which is the tell them what you're going to tell them.
Yeah.
And what I always say to people is we need a roadmap. Tell the judge where we're going with this. So the first suggestion by that person is the right suggestion. So it's, start with all your sort of pleasantries, may it please the court. If you're the appellant, do all your introductions. I appear on behalf of such and such. Mr. So-and-so appears for the respondent. I will be seeking to persuade your lordships that the appeal should be allowed. Within my submissions, I will be making 3 points. The 3 points are, and you tell them in a sentence or two, the contract was not valid because there was no consideration, whatever. These points can be found at paragraphs 2, 3 and 4 of the skeleton argument, which I will move on to during my submissions. And then you jump in. If my lords and my ladies, turn to paragraph 2 of the skeleton argument, you'll find my first point, which deals with whatever, and move on.
Yeah.
So long and short, within your introduction, tell them what your 3 points are. Just headlines. You don't need to go any deeper than that. Just tell them the headlines.
Yeah, great. And I suppose in real life, it's important in mooting as well, because the judges know exactly where you're going, they know what you're about to cover. In real life as well, I suppose it's really helpful because the judges will have read your skeleton argument, won't they? And I bet sometimes they say, oh, I've seen your skeleton argument, you don't need to address me on point 1 and 2, I'm only concerned about point 3.
Precisely.
And everyone's like, great, let's move on, he's with me over there. Or he could even say, which might be a little more nerve-wracking, but okay, yeah, I'm with you on those points, but you don't quite address the point I'm concerned about, which is X. And then you're like, right, okay. So you've got to address something a little bit different, or there's something you may not have thought about. Is that common?
All the time.
Yeah.
So precisely. And that's part of the reason why you would do it. Obviously it's courteous and it's helpful for your submissions. But once again, the judge will tell you where the points of contention lie. Mm-hmm. Because there is a difference in terms of what happens in, simulated scenarios whereby every point needs to be made because, you're being tested or you're trying to practice the skill. Whereas in practice, a judge isn't going to listen to submissions if they already agree with you. So they'll tell you, and it very much guides you, okay, this is where the judge has concerns.
Yeah.
This is, these are the points that I need to address the judge on.
Yeah.
And sometimes you might find you don't even need to make submissions. Slightly different point, but it made me think about it when you were talking there. So during one of my hearings earlier this week, the individual that was against me had to make a last minute application. And so she stands up, makes the application, and then, okay, yeah, right. Few little notes, and I was ready to stand up and oppose it. And before I even need to get to my feet, the judge says, nope, the application is refused. So I didn't even need, obviously the judge gave reasons for it, but I didn't even need to stand up and present any submissions on the point. So,
nice.
It obviously in a simulated scenario, you'd have both parties, you've got to present all submissions on this. In this, it was a last minute thing, the judge just said, computer says no.
Do you like that if the judge kind of does it for you, or the barrister in you're like, oh, when you've got something ready to say?
There's an element of that. And also sometimes you're thinking, particularly during, let's say you're mitigating and you're ready to present all these things, and you've spoken to the client, you think you want the client to see what I'm going to say here.
Yeah.
And the judge just takes the wind out of your sails and says, Mr. Dove, if you're going to tell me this, this, and this, I'm with you on that, and therefore I'm going to impose unpaid work or whatever.
Particularly if you've got a private payer and you want the client to get the money's worth. Try and make up something to say.
We need some extra submissions here.
Brilliant. Okay, hopefully that answered that question. Let's move on. Is there a given phrase to use when answering judicial intervention, like when you start your submissions with, may it please the court?
In short, no. So there's no stock phrase that you use to preface your answer. Now, there's nothing wrong with inserting a phrase because it might help you.
Yeah.
And the reason I say that is because judges ask questions, and sometimes they might be difficult questions, and sometimes it can be something off the fly. There's nothing wrong with, while you're trying to think of your answers, simply going quiet.
Yeah.
I do that sometimes. I'll simply go quiet while I'm thinking, and the judge knows that you're thinking, so there's nothing wrong with being silent. But some people like to fill the silence just because they don't feel comfortable with silence. So it can be, Your Honour raises an interesting point, and the way in which I will deal with the point is as follows. So it's just while your brain's spinning at 5 million miles an hour trying to think.
I remember one of our competitions, one of the best competitors I ever saw.
Yeah.
And every time he got judicial intervention, his phrase in response was, "I am grateful."
Yeah.
"My lord, I am grateful. My lady, I'm grateful." And I was like, oh, that's a nice one.
Yeah,
but maybe it doesn't buy you a lot of time, but it would just acknowledge it, and then he'd have a think, and then he'd answer the question. So there's my take.
And it shows deference to the court as well, doesn't it? So,
yeah. Do you know which one I'm talking about?
I know exactly what you're talking about.
He's a judge for us now.
He certainly is, and not only, this is a bit of a superlative episode, but I'd say possibly the best we've ever seen.
Yeah.
This,
I always think of him,
this particular competitor, I think, was an undergraduate at the point of competing, and you could put him in court and would be better than probably 70% of the advocates in the country.
Wow.
It's frightening how good some people are that take part in these competitions.
He was just effortless, wasn't he?
Yeah.
He was. Anyway,
let's move on.
Let's move on. We have to get a shrine of this person if we carry on talking about him. Okay. In what way would you present case law in your arguments? So this is kind of a back to the fundamentals, back to the basic question, because we always say every point you make must be backed up by authority.
Yeah.
So in practical terms, how do people do that, John?
Okay. So you've hit the nail on the head there, Hayley. So every point must be backed up by authority, and in effect, this is what mooting is testing, isn't it? It's testing your ability to apply case law to a set of facts, and also to an extent how cleverly you can think about the case law. Sometimes the case law is against you, and you need to either distinguish it or find unique or esoteric points that can help and support your argument. So you've got your skeleton argument, which is the foundation, and every paragraph in there will probably move on to a new point, and you'll say whatever the point is and whatever the case is that supports your argument. So you might say, my lords, I'm going to move on to paragraph 3, which is that the contract was not valid because there was no consideration. I'm using this point, I'm just trying to think of the most basic piece of contract law.
Yeah.
So you'd say that it was established in the case of whatever, and you'd get your legal principle. The way in which that applies to this case is as follows. So you make the point and apply it, or you can make the point that you're going to make, and then you can say, an authority for this point comes from. So there's two ways you can do it. You can establish what the law is, and then say how it applies, or say the point you're trying to make, and then say how it's supported.
Yep.
And then taking that one step further, you can either simply say, this was the ratio of the case, this was what was established by the case, or there might be a specific point that was made by a judge in the case, and you think that sentence said by that judge, or that paragraph said by that judge is really, really powerful.
Yeah.
and you therefore want to incorporate that. So you can say, support for this point comes from the judgment of Lord Reed in the case of Smith and Jones. If I can ask your lordships and your ladies to turn to page 56 of the bundle, whatever it is. So if ever you're going to be quoting a specific line, tell the judge exactly where they can find it. Wait for the judge to find that line. So tell them exactly what page, what paragraph, what line, what word, and then quote it.
Yes. Now,
be careful when you're quoting, because don't, and I've seen this before, don't try and quote a sentence out of context. So, it's very easy to think, oh, well, if I only quote half a sentence, this sounds great. Yeah. But that's not what was said. No. The full sentence was said by the judge.
Yeah.
So...
you read a sentence that says, oh, and that bear was brown. You're like, great, I need the bear to be brown. So that's all you read. But then you read the actual bear. It says, that bear was brown because he'd rolled in the mud. When he got washed, he was actually a white bear. And you're like, oh, no.
Yeah.
That was a funny example.
That was a good example off the top of your head, though, wasn't it? Yeah.
A brown bear came to me, but there we go. So that's why it's important to read the whole thing, because you can bet your bottom dollar the judge will.
The judge has, or your opponent has, and it's wrong for two reasons. A, you're misleading the court, which, if you're in practice, is an no. But also, as you say, if the judge goes, well, have you read the rest of this sentence? And you've got egg on your face at that point.
Yeah.
So, yeah.
Egg on your face. I like that too.
Going with all the analogies here, aren't
we certainly are.
Yeah.
There we go. So, hope that was helpful, and that is how you use the case law.
Yeah, absolutely. This video is brought to you by Speed Mooting. We are an organisation that help aspiring and junior lawyers. We run online and in-person advocacy and mooting competitions. We do online advocacy and public speaking training, and we run lots of other events to assist people on their legal journey. To learn more, visit our website, speedmooting.com.
So we touched on before, when you lay out your roadmap for the judge, sometimes they will say, well, I'm with you on this point. What I'm concerned about is this point. And this is one of the reasons, isn't it, why you need to know your material so well.
Yeah.
And you need to not be dependent on a script.
Yeah.
Because if suddenly the judge says they don't want to hear about 1 and 2, you're panicking because that's not how you rehearsed it, that's not how you memorised it, or that's not what your script tells you to do. You need to be able to go off piece.
Yeah.
So this is a related question to that, John, which is, if the judge asks us to move on to a point which skips past multiple other points, do you have to go back to those points later, or do you just disregard them?
No, of course, move on to them. So I think where this question comes from is that one of the points I was making the other day is that normally you would work chronologically through your skeleton argument because that's the way you would have drafted it. Of course, with ours, we provide generic skeleton arguments, and people don't have to make every point within them. People can address those points in a different order, and that's why we try and keep them as generic as possible. So let's say you're in a traditional moot whereby you've drafted your own skeleton arguments, and let's say you've got 8 paragraphs within there, and so you're working your way through whatever point you've made at paragraph 2, and the judge says, okay, fine, but I'm more concerned with paragraph 8. Whatever point you've raised there, address me on this.
Yeah.
You move on. You don't turn around to the judge and say, I'll come to that. If the judge is asking, you move on to that point.
Yeah.
Now, once you've done that, once you've addressed that point, you've effectively covered that off, haven't you?
Mm-hmm.
Come back. If you still need to make the points in paragraphs 3, 4, 5, 6, 7, don't skip them, because, obviously they're still relevant. It just means you've taken your submissions out of order. So if you still think those points are relevant and you need to cover them off, go back and cover those points.
Yeah.
And as you say, Hayley, this is why you need to be dynamic. This is why, the number of times I see it whereby people just have a script and they're just going to read it, you're setting yourself up to fail. There's nothing wrong with having a script, nothing wrong with having it there to help and guide you, but you need to practice your submissions many, many times so that if the judge is going to take you out of order, you know your material.
Yes.
Because you'll be making the same points, but the judge is asking you a question, so it's going to come out slightly differently to the way that you've got it on paper.
Yeah.
So you need to know the material so well that you can just discuss it.
Yeah, and really understand the point you're making, because they might say, as you said, well, I want to go to point 7, point 8 of your skeleton argument, but they might not phrase it that way. They could just say, okay, I see your point there, but that's not what the case of such and such tells us. And you're like, okay, where's that in the skeleton? And if you don't know it well enough, you're like, oh, is that 0.5? Maybe it's not. Maybe that's 0.6. It might not be laid out for you that way, so you just need to know what that case means and have your rebuttal ready somewhere.
Exactly. That's a really good point to make, actually, yeah, because that's how they generally phrase it. And I think you'll know when you've practiced enough and you know the material well enough, because if you were to talk to another law student about your moot, you could explain all the points that you're going to make.
Yeah.
You wouldn't need to go, let me review that. You can go, well, the case is about this.
Yeah.
So if you were having a general conversation, yeah, this is what it's about. These are the cases we're relying upon. These are the points we're making. If you know your moot to that extent, you're prepared.
Yeah. Is it beneficial to try and rebut the opposing counsel's arguments within your own submissions?
This is probably sort of horses for courses, really, because, before the moot, you will have seen your opponent's skeleton arguments anyway. So you should be dealing with the points that your opponents are going to make anyway. And normally, you're going to be arguing two sides of the same coin. So, in theory, whatever you're saying, naturally your argument should be rebutting the opponent's arguments anyway, because ultimately what you're trying to say is, my argument is right, it carries more weight, therefore they're wrong.
Yeah.
Okay. You're not saying it in those terms, but that's the implication. That's mooting in a nutshell, isn't it? You can say, well, my learned friend makes reference to the case of, A and B, and makes this point. I would submit that a more relevant authority is, so you can preface some of your submissions with, my learned friend says this, but this point is stronger, but you don't always need to necessarily make those points, because it's going to come out within your submissions anyway.
Yeah.
And quite often in mooting, you'll tend to find that the law favours one side over the other. We always try and do moots that are 50-50 on the law, and I think we've pulled that off on a few occasions, but it's not always possible. And sometimes there's a seminal case, a leading case, and you've got to get around that. So normally, take as an example, we did a Section 18 problem, didn't we? So GBH with intent, and the case of Crown and Brown, I'm sure all law students remember that case, in effect says you can't consent to GBH save for certain circumstances. Okay, so there's some policy arguments, some exceptions, etc. But as a general rule, most of the time, you can't consent to a GBH. And the case was all about someone trying to run the defence of consent to a GBH.
Yeah.
So that's your big hurdle that you've got to get past. So at some point, you need to address the case of Crown and Brown, which is obviously what your opponent is hanging their argument on. So you've got to try and get around that. You need to think, well, my learned friend relies heavily upon this case and makes this point. However, I would submit it doesn't apply. It can be distinguished. It can be set aside, whatever, because So that's where you need to deal with it. But ultimately, in most cases, it's a matter of personal preference as to how you want to present the case. Whether you want to say, my learned friend says this, I say this, or you just simply present the arguments, because naturally, whatever you're saying is going to be counter to what they're saying anyway, and hopefully should cover off those points.
Great. And I suppose it's something that comes down to a bit of experience as well, because an inexperienced mooter, you probably do think, I need to be really argumentative and I need to bring my opponent down. My lord, that point my opponent made is wrong in the law. But really, when you get more experienced and more comfortable, you realise that you can be respectful but still get your point across. And I imagine that, well, I know it does come across better, and I imagine that the judges probably like it more as well, so you don't have to say they're wrong. It's my learned friend raised a good point. I would address it as follows, my lord, with this case. So you're always respectful of your opponent, even though essentially you are trying to win their arguments.
Absolutely, never ever talk down about your opponent. Always show respect, and that's a good way that you've raised that there. And you could even say, your lords may be persuaded by the case that's been raised. However, I would address it in this way. Whatever.
Yeah.
So absolutely. Coming on to the point of how aggressive and all the rest of it you should be. I always remember at university someone telling me about, I think they must have judged the moot, so they must have been in third year judging a first year moot or something, and they said they watched this moot who'd been brilliant throughout, really good submissions, they were on track to win the moot, and then finished the moot by grabbing a textbook or the Libre Archfile or whatever it was, thumping it on the table and going, I rest my case.
Oh, brilliant.
So whatever you do, don't do that. There's no resting of case. It's unless you can assist any further, and don't thump your books on the...
No. That's like the legal equivalent of a mic drop.
Yeah, literally, yeah.
Obama.
No, judges will not like that at all.
Not at all.
I think that's another a really good point, isn't it? Judges don't like to be told this is right, this is the answer. My client is obviously not guilty. They like to be persuaded, but they want to make the decision, don't they? So it's almost like a challenge. You've said this before, isn't it?
Yeah.
My lord, you will see there's no other way possible to interpret this. Well, actually, I'm going to find another way to interpret this because you ain't telling me what to do.
Exactly.
So sometimes there's subtle differences between things like being courteous or being persuasive over being too direct. Is the difference between winning and losing a moot or a case in real life.
Yeah, precisely.
Okay, so I think that's enough for mooting questions. So we'll move on to some personal questions.
Okay.
What extracurricular activities would you recommend that students pursue to stand out in their applications?
Okay, a couple of things. Number one, most universities will have some sort of legal clinic or street law or something like that. And generally speaking, that's where members of the public will come in, they'll speak with you, they'll tell you about their legal problem, and you will normally draft them a letter of advice under the supervision of a solicitor within the law school, or you might even need to draft a letter to help them with their problem, write to a company or whatever it might be. So that's a really good experience for helping you with your conferencing skills, so taking information from a client, helping you with your drafting, helping you with legal advice. So you're building up great skills there.
Yep.
If you've got societies within your university, a law society, bar society, advocacy, whatever, get involved, become a member, try and get on the committee, because most application forms, whether it's training contract or pupillage applications, will ask you what roles and responsibilities have you had.
Yeah.
So by getting a role on the committee, it helps you to answer those questions. And then outside of that, any part-time job is important. Even if you, I don't know, working at McDonald's, let's say, you're still dealing with members of the public all the time. It's building your personal skills, building your people skills, which I think is massively important. I don't think that any form of lawyer, regardless of what your practice is, I don't think there's any lawyer that can get away with not having good people skills. So it's a really good way of building your skill base.
Yeah, brilliant. So they are extra stuff that you can do to build up your CV, build up your skill base, build up your experience that you need to become a good lawyer.
Yeah.
In addition to that, I would say as well, it's important to do something outside of the law. It's important to do stuff just because it's fun and because you enjoy doing it. So your own hobbies, whatever they might be, they're worthwhile as well, and you might pop them down at the end of your CV. We see it, don't we? And in my spare time, I enjoy. And it is important. They're talking points in interviews sometimes, and it doesn't have to be anything crazy. You don't have to be a kart racer. You don't have to be an Olympic swimmer, whatever it might be. Even if all yours is I like to spend time with family, I like to cook, whatever it is, just be truthful, and you never know who that might resonate with in a pupillage interview or a training contract interview. And on another note, it's just really important to have a way that you can switch off. That's really important for the work-life balance. So there's no, you must do this extracurricular activity. All the budding lawyers are doing X. No, whatever you want, whatever you enjoy, pursue it in your spare time, and it helps keep you grounded. Yeah,
absolutely. I mean, as you say, not everyone's got the opportunity to go and climb Mount Kilimanjaro or whatever it might be. We certainly didn't, Hayley.
No, we did not.
My hobbies were very low cost when I was a kid. It was playing footy with my mates. And
what's the mountain in Colomendy? I did climb some sort of mountain when we went to Colomendy.
Movame.
Maybe, yeah. Must be, mustn't it?
Yeah.
I climbed that one.
Take that to the nth. I love exploring the...
Next question. This is a good one.
Okay, go on.
If you could go back in time and give one piece of advice to your younger self, what would it be?
Okay. Thought about this one before. Quite frankly, I'm very happy with where I am in life and the way things have gone. So I've spoken many times about the fact that it took me a long time to get into this profession, and I could have made life a lot easier for myself. But if I did that, I wouldn't be in this position. It's like, I've said this before, it's like on Lost. What's happened has happened. Okay. But let's say I could, and let's say I did want to change something. I would give the piece of advice to myself: get involved. So we were talking about experience on the last question. If I got involved, if I was a member of a committee, if I did some more extracurricular stuff, I would have been able to answer the question of, well, what roles and responsibilities do you have, rather than... and also it probably would have given me more ammunition to answer the questions like, why would you make a good barrister? You know, because I could talk about why I'm going to be good at conferencing, good at advocacy, you know, whatever it might be, having good organisation skills. So, and have more evidence to back up those answers, short, rather than I went to a good union, did well in my exams. You know, so I'd have something to set me apart. So that would have been my advice. Just get involved.
Yeah, that's a really good one. I don't know if this is technically advice, but if there was something I could go back and tell my younger self, it would be, you know, just believe in yourself and have confidence to like just be who you are. Because I remember back when I was at high school, I mean, my high school wasn't a great high school. It's an academy now, so that tells you what you need to know. So I knew in high school, you know, I was quite confident in my own abilities. I knew I was in the top percentile of intelligent people in my year. I was really ambitious, and I never doubted that, you know, I was going to become a lawyer. Same with college, really. And then when I got to university, I went to university in Manchester, and suddenly I was exposed to people I'd never rubbed shoulders with before. You know, people from really wealthy backgrounds, people from the really high-end parts of Manchester, London.
Into private schools.
Exactly. Families that are all lawyers. And
they've all got the little Ralph Lauren jumpers and all that.
Yep. And when they speak, they just sound right, you know? And then you listen to them and go, oh God, I don't sound like that. I'm not as persuasive as them, or I don't think I mustn't be as intelligent as them. They just look and sound so much better. And then before you know it, you know, it can chip away at you, and that's when, you know, imposter syndrome creeps in. And part of our grades in university, definitely in first year, was about speaking up in seminars. And that used to be like the scariest like part of it for me. I knew what I was talking about, and I, you know, still getting the good grades and stuff, but having to like speak up, it was like, oh God, I don't sound like these people, and I'm probably, you know, maybe I'm wrong, because when they talk, they just sound so much more like lawyers than me. And it takes a while, and I say it's a strange one, because even if I could go back and say to myself, no, you be yourself and you like stay true to yourself, it takes experience to learn that. It's, you know, it's a hard thing to grasp right away. And I think being in the profession helps, because once you're in the profession, you see it's made up of so many different people from all walks of life and from all accents. Of course, there's still a big majority of people that, you know, speak what do you call it, the King's English, and that speak that way, and because they have been raised that way, and they, you know, they make great lawyers just as much as anyone else does, so they deserve to be there. But, you know, so do we. The little Scouse girl from Verzackley is still a really good lawyer. So
definitely.
It takes time, but I wish I could give myself a little whisper in the ear in first year of university and go, it's okay, you don't need to change, that's them and that's great, but this is you, and you know, you're also great.
Because it's absolutely frightening, well, not frightening, but, you know, a little bit daunting when you first go to uni, and, you know, you're the first one to go to uni, you've never been in that environment before, and you're mingling with people that, you know, you've just never come across before, and, you know, fair play to them, but they are super, super confident. I don't know what is taught in these private, you know, I don't know if they have public speaking lessons or conference lessons or whatever, but, you know, fair play to them. That, you know, they're coming in very, very confident.
They're just self-assured.
Self-assured, and you know, all credit to them. but it's off-putting. But you go and you wow, and then going to the Inns of Court is next level as well.
I can imagine.
And so you just gotta, if you find yourself in that position and you are a bit overwhelmed, just know you've done the right thing to get there. You've obviously.
You're just as good.
You're just as clever as those people to be in the same institution as those people.
Yeah.
So be confident in yourself. Keep the work up, and you're going to get there. And as Hayley says, you're going to break into the profession. And
it is a really friendly profession. Like, for the most part, it really is. We've talked about this before. There's so much camaraderie at the bar.
Yeah.
It can be the same in your law firms. There can be you from Liverpool can end up being best friends with someone from, I don't know, Oxford.
Oh,
it doesn't. It's everyone. Everyone is welcome.
And I think stemming from the same point as well. And this is something we were talking about the other day. So getting into the profession is really, 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 really hard. Very difficult. Once you've got that piece of paper, once you're qualified, it's so much easier to assent. So you think about it.
Yeah.
Obviously, I didn't get a pupillage. Fought very hard to get a training contract, and I think about all these places where top firms where didn't have a hope in hell, didn't even get interviews for training contracts. Likewise, even the Crown Prosecution Service, couldn't even get a pupillage or training contract there. And yet when I'm qualified, I go straight in as a senior Crown Prosecutor.
Yeah.
I've had offers from all sorts of other firms to move across. So it's crazy that you think, you fight tooth and nail to get into this profession. But once you're qualified and go, yeah, I've got a track record, got all these cases, etc. Oh, come on in. Come on in. So that's the hurdle. Once you're in, and you're laughing.
Yeah. And you'll know, 5-10 years qualified, whenever it might be, you'll look back and think, it didn't need to change. I'm glad I didn't change.
Yeah.
So yeah, don't be disheartened. If everyone around you doesn't look and speak the same as you, it doesn't mean anything. Stay true to yourself.
Yeah, be yourself. Be yourself.
Aww.
It's a nice little place to end, isn't it?
I think so. You've got to get going.
I've got to get going.
Where are you going?
Only Chester, to be fair.
Not too bad. Not too bad.
But yeah, so it's a bit of an interesting weekend ahead.
Mm-hmm.
We've got a first race weekend of the year, haven't we?
Yep.
Non-championship race, though. Championship doesn't start until next month, so it's a bit of just to ease us in before the championship starts. And on top of that, it's a double whammy this weekend. It's the Royal Rumble.
Oh, yay.
Yeah.
I've been counting down the days.
Sarcasm? You think?
I think, yeah. Even on your Netflix, it's popping up and saying, it's coming up. So it's going to be exciting. It's one of them this year. I don't know who could win. The odds have been changing. So a couple of months ago, the odds were on for The Rock to win. I don't even know if he's in the Royal Rumble.
It's got to be John Cena.
I think there's a good chance of John Cena winning the Royal Rumble. He's on his retirement tour. He's tied with Ric Flair for 16 world titles. So is he going to break the record and get that 17th world title this year?
Woo!
For those
if you know, you know.
If you know, you know. That's Ric Flair's catchphrase. But yeah, he came out on the first episode of Raw on Netflix and said, well, he's not really got time to work his way up to the number one contender spot, so he needs a raffle ticket basically to get his world title shot, which is either win the Royal Rumble, win the Money in the Bank, or win the Elimination Chamber. So he's entered himself in the Royal Rumble. Is he going to do it? Possibly, but I think there's a few other good candidates out there. CM Punk, Roman Reigns, maybe. He's obviously going to want his title back. Seth Rollins is an option. So,
isn't he an actor?
No, you're thinking Seth Rogen.
Oh. He's not at the Royal Rumble.
He's not at the... Well, you say that. You do get celebrities that just enter every now and again, but it doesn't really happen as much these days. So if you want me to commit one way, I'm going to say the winner of the Royal Rumble... I keep going backwards and forwards on this. CM Punk.
CM Punk. There we have it. We'll see next week if either of us were correct.
Yeah.
And your word for this week is obviously got to be Royal Rumble.
Yeah, it's got to be Royal Rumble.
Yeah.
Yeah.
Well, we better finish up, John.
Let's finish up there because I need to skedaddle and get to court. So we'll see you next time. Take care. Bye-bye.